These generation gaps can be problematic when people aren't aware of their default style and they just assume everyone else sees efficiency, risk, and responsibility the same way they do. So
generative AI still has a lot of steadiness in its outputs. Right now, generative AI is very kind of a people pleaser. It's not necessarily always giving you the right answer. It's giving you the answer sometimes that you want to hear or that you it thinks that you're looking for.
For the most part, different career stages experience AI differently because the work is different, the risk is different, and the accountability is different. So you want to govern accordingly.
Welcome, and thank you all for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speakers for today, Alicia Pollard and Avi Aiken Fernandez. Alicia Pollard has served as legal and strategic advisor in many different fields, from corporate matters in big law, transitioning to business and legal affairs in media and entertainment, and later centering her practice around technology, with a particular emphasis on data protection and AI risk management. Alicia has worked with a diverse range of companies and tech enterprises to ensure digital responsibility and security in all areas of commercial transactions. She is certified through the International Association of Privacy Professionals, the IAPP, in information privacy and AI governance. Avi Aiken Fernandez is an accomplished attorney, legal scholar, and political scientist who explores the convergence of emerging technology, law, and leadership. Her current research focuses on the critical issues of anticipatory governance in artificial intelligence, AI, and how judicial institutions can be strengthened to better serve the public interest and maintain trust in a rapidly evolving technological landscape. The webinar presentation that you're about to watch will be approximately 1 hour, and Alicia and Avi will be taking questions from the audience once the presentation is wrapped up. You can submit those by clicking into the Q&A button in the control panel at the bottom of your screen and sending them in there. Now, without further ado, here are Alicia and Avi to discuss profiling power, leveraging generative AI in ethical leadership.
Thank you, Nina. And thanks to everyone joining in today. With this session, Avi and I will be discussing how leadership self-awareness helps to inform ethical decision-making, specifically when it comes to the adoption and use of generative AI, whether that be in the workplace, in court, and with general legal functions. And I'm going to just use the term AI, but I'm referring to generative AI. So we're looking at the cross between AI issues and leadership psychology, and we'll explore how personality and character in leadership, such as one's values, their behaviors, and their communication style, guide the way organizations and teams adopt, govern, and use, emerging technologies such as AI. I personally have always been deeply interested in leadership mindset and conscious professional growth. And over the years, I've had the chance to learn from and experience different leadership approaches to new technologies. So I'm happy to share insights on some of the strengths and challenges from different projects and teams that I've worked with, and to highlight what I've seen that helped to refine workplace culture and to remain aligned with company values and attorney ethics. So in this session, and I want to shift over to the agenda slide, if we can. In this session, we'll look at leadership personality as a factor in how AI is operationalized. We'll briefly look at 2 behavioral and personality assessments, which can serve as frameworks to understand how those tasked with decision-making might generally think about, act on, and use AI. And this should hopefully show how diverse leadership styles affect its governance within a company or for a firm, or its use in the courtroom. I'll then provide a few instances that I've experienced where leadership styles in the workplace presented differently with AI considerations and matters. And then we'll discuss a few cases that Avi pulled with reference to the model rules and the attorney ethics that apply. And I want to note that different leadership styles are always present in any context, not just with AI, but here, because there's so much uncertainty and a lot of ambiguity around the tools, the current and future risks, and the newness of all these legal standards, it expands the need for collaboration and consistency and really clear judgment when having to make decisions on AI matters. So with AI, much of the focus and discussion we hear in the legal space has been around how to use the AI tools. We hear about all the privacy risks, the IP battles, and all the various laws and policies that are shaping up pretty much across the globe. And generally, the approach is to look at AI with more of an outside in lens, meaning we'd say, okay, these are all the AI tools that are out there. Which of those should we use to remain competitive and compliant? Or we'd say, okay, well, these are the legal issues, the AI legal issues that our clients and our business teams face. What does that mean for them? And then by extension, what does that mean for us? The other way around, which isn't often considered, begins with a who am I, or who are we as a team or a company or a firm, and what are our strengths or challenges? And then we think about what AI tools can amplify those strengths or develop competencies to address those challenges to help us better serve our clients, our business teams, our stakeholders, whoever. So with this subtle shift in thinking, we consider the decisions we make as a reflection and a result of who we are, and what we need individually or as a team. And it's rooted in self-concept and self-awareness, and then looks to the outside to support that. And that doesn't mean that we just disregard the outside in analysis. Obviously, we need to stay on top of all the laws and the trends and the tech that affect our practice. But by also considering this approach, we're looking at technology adoption as an extension of leadership awareness, which is important to make sure that we're not projecting our own limiting beliefs or practices, if any, in this field, and that our representation remains grounded in ethics. Most of us already know about all the challenges that come with AI. We have attorneys using the tools in researching and drafting, sometimes without proper oversight or without understanding all the risks. We see all the confidentiality and the data retention issues, all the cybersecurity risks. And then we hear about all the pressures to adopt AI fast or first to remain competitive. And there's the other side of it where there's resistance to its use from, a lack of trust in the technology. So, and there's much more to consider. So, especially with the way AI has evolved in just a short amount of time, we can't even be sure of what's possible even a few months from now. So, as we'll discuss, leaders and decision makers perceive and use AI through their own cognitive lens and behavioral patterns. So it's worth understanding the impact of your own or someone else's leadership style, because this can help us anticipate how decisions could be made when technology introduces ambiguity, which AI does pretty much all the time. And it also helps to signal potential blind spots in different areas of leadership based on personality or behavioral style. So I want to shift things over to Avi to give a brief overview of two of the personality assessments that can be helpful in understanding leadership style.
Hi, thank you guys. Good afternoon, everyone, and thank you for joining us. So just doing a quick temperature check. If you look at these 5 responses, we're going to start talking about DISC profiles and Myers-Briggs assessments. So kind of think to yourself where you are in this spectrum. Are you familiar with DISC or Myers-Briggs? And do you use it? Have you not heard of it? And we're going to get a little bit more into the profiles.
And for any of our audience members, you can put those responses in the Q&A. That should be a button in your control panel, and you can fill that in there.
Thank you. And how would I see their responses?
Yeah, so you should be able to click the Q&A button on your end. Avi, it might be under the More section in your control panel, but I can also read them out to you if that's helpful.
Yes, that'd be helpful, the readout.
Wonderful. All right, so we have one response so far. It's from Carolyn. They selected A, I know my profile and use it actively to lead.
Okay. Thank you, Carolyn. I appreciate the response.
An anonymous attendee, we have two responses from anonymous attendees. One selected B, I know my profile but don't apply it. And then another selected D, I'm not familiar with DISC or Myers-Briggs.
Do you know if, can they specify if it's Myers-Briggs or DISC that they're unfamiliar with, or both?
Sure, we can definitely ask them to do so. We're also getting another A from Eileen, and we have a C from Radu. So it does appear, okay, this anonymous attendee clarified that their D selection was for actually both of those models. So it looks like we've got a pretty wide spread of people who have experience and then maybe don't have as much familiarity.
Thank you, everyone who participated, and thank you, Nina, for the readout. So continuing on with the profiles. So framework one that we're going to first cover is the DISC model. So DISC is a little bit newer, and this kind of breaks down into 4 quadrants. So you have your D, which is dominance, people who are more direct or strong-willed, focus more on results. You have I, which is influence, and those people tend to be a little bit more optimistic, enthusiastic, and kind of persuade. And then you have your S's, which are steadiness. So even-tempered, accommodating, patient. And then you have your C's, which is cautiousness, conscientiousness. These people tend to be a little bit more analytical or detail-oriented. So if we're looking at these quadrants, people towards the left side, towards the top quadrant, the D's and I's tend to be more outgoing. So these are our more extroverted people. And then people in the bottom quadrants, our C's and S's, tend to be more reserved or introverted. Most people are style blends, meaning they have at least one high-ranking secondary trait, and about 15% of the population have 2 secondary traits. So when you're interacting with people, it's very rare that you're just dealing with one type. There's usually a blend of traits taking place. And so that's the DISC model framework. If anyone's interested in that more, I can point you towards resources. And then we're going to move into our Myers-Briggs. So Myers-Briggs framework is a little bit more established. I think Myers-Briggs has been around for at least 50 or 60 years. And with your Myers-Briggs framework, it also separates into 4 quadrants. And basically what happens is you pick one from each category. So your source of energy, you're either extroverted or introverted. For how you receive or how you get information, that's usually broken down into either sensing or intuition. Decision making is thinking or feeling. Do you go with your gut, or do you go with kind of the reasoned analysis? And then how you relate to the world, so judgment or perception. And when we think about Myers-Briggs, there's a 16 possible combinations if you take one from each category. So it's not really possible to just guess someone's Myers-Briggs. Some qualities you might be able to identify as far as whether they're more extroverted or more introverted. But as far as the deeper stuff, that's something you wouldn't really know just by working with someone or meeting them at like a networking event or something along those lines. Myers-Briggs is generally very deeply personal. Whereas DISC is more observable behaviors. And as far as the overlap of the two, we have this nice chart that Mr. Branson created, which kind of shows how the 4 quadrants of DISC overlap with Myers-Briggs personalities. So if you look at each quadrant, you still have your D for dominance, your I for influence, C for conscientiousness or cautiousness, and your S for steadiness. And you see that D's and I's tend to be more extroverted, as we mentioned. and C's and S's tend to be more introverted. Obviously, with any personality profile, it doesn't, define you, but it is a useful tool to kind of think about how you interact with the world, how you interact with others, and kind of what's important to you in the workplace, especially when we're thinking about generative AI adoption. So I skipped through the slide earlier, but in the statistics, about 80% of the workforce population thinks that generative AI is useful. But the side note to that was only about 30% of that population of that population, 30% believe their organization is moving too slowly in AI adoption. So if you're in a management or a leadership position in your organization, you want to think about your profile and how those things interact with your adoption for AI, how you approach it. Are you more kind of quick to move forward with new technologies? Are you more cautious and conscientiousness? Or do you, focus on the results or getting the end product? So Alicia is going to talk a little bit more about some use cases. And as we go through the use cases, you want to think about your own profile, perhaps the profiles of others that you might have encountered, and how that kind of plays into decision making, especially when we think about new technology adoption like generative AI.
Okay. So, as Avi mentioned, I'm going to very loosely apply some of these concepts to a few of the matters I've worked on, but I'm going to focus more on how self-awareness in general can impact real-life decision-making with AI matters. Obviously, nobody's asking anyone else to run a personality test to understand what their profile is, but most times you can get a general sense of someone's style and then maybe anticipate their leadership instincts. And also, DISC and Myers-Briggs aren't the only two assessments that can help understand leadership styles. There are many others that are well regarded. So if you do find value in doing an assessment to understand your own tendencies, which I see quite a few you have, it might be worth measuring it against your own thoughts about or use of AI to see how aligned it is. So one example where I worked with a range of different leadership styles all in one project was having to submit for board review the rollout of an AI try-on tool. So this was or is a publicly traded retail company in clothing and apparel. And they were launching a tool that would allow customers to pick out clothing and then upload their image into the company's app. And it would then show them how they would look from all angles with the clothes on. So basically placing digital clothes onto the customer, which is a pretty cool feature because it's great for customer engagement, and it would also track customer preferences and a whole bunch of analytics and metrics, which were useful for the company. And this was the first AI project after the board already pretty much pushed play with the decision to become, for the company to become more AI driven. And there would be a series of other projects that would enhance the customer experience using AI. So before this project went up for review, we needed to map out the business case, prepare the risk assessments. We had lengthy discussions with the tool developer and the audit committee reviews, among many other things that had to happen. So at this, I want to say development stage, leadership styles started to surface, and there was discussion about competitors and how timing matters and, how we need to roll this out sooner rather than later. Then during our legal and risk framing discussions, the process started to slow down with questions about data usage and privacy risks. Can we roll this out in all markets, or should we keep this regional? Where's the data stored and processed and so on? So the expected time frame for launch shifted further and further into the future. And this was a huge issue that, we hit a snag on quite often. I'm giving a very broad recap of how this played out, but generally during the rounds of internal development talks on strategy and risks, the business side leaned more, I would say, dominant, or trying to push quickly, and they were more focused on beating the competition. They were more decisive and results driven, and they felt like we were over engineering the tool, and they were comfortable with a degree of uncertainty if there was monitoring, whereas legal and privacy weighed more conscientious with a more risk-aware approach, having resistance to a quicker launch time and wanting more information and guardrails, and definitely more certainty about how to manage all the risks from all angles. And we had to keep in mind how the board would weigh in on this project. And we knew that many of the same reservations and thoughts and motivations that came up in our discussions would likely be reinforced while under review. So we had to consider and anticipate questions about customer trust, safety, and the precedents being set for future AI projects. So for the most part, the idea was generally supported from the start, but timing and reporting were key sticking points that took some time to hammer out. As the legal professional in this situation, awareness about our own decision-making style helps us to relate to those who think and decide the same or similar to us, and we can communicate that line of thinking with others who might have differing or opposing views, to the extent needed to bring alignment in a team setting. Just as well, we should also be able to detach from our own personal thoughts on what we think should happen to the extent necessary to allow cohesion with decision making. When we can say, I know myself to be this way, to act this way, think and decide this way, whether it's naturally who we are or just because of the nature of our role, we basically stop our viewpoint from becoming the objective reality. And this self-awareness stops you from projecting and from mislabeling difference as resistance. And the competitive urgency around AI mixed with expectations and uncertainties and risks create a pressure that can easily have everyone pretty much default back to and operate from the I or me or this way space rather than thinking objectively. So part of our role as legal professionals in most settings is to be the translators and integrators of all lines of thinking, not just advocate for our own. And this helps to balance conversations around AI and reduce friction or delays, which over which perspective or which approach is right. So moving on to the concept of generation gap with respect to AI use. Now, when it comes to this isn't an example from my experience, but more of a dynamic that can be present with career stages. And I'm not referring to specific age groups as having certain personalities or behaviors or tendencies. So we're not categorizing or generalizing any particular age range. We understand that the use of technology at any age is always different based on each individual person. But it's included here as an example because this concept floats around a lot when people think about who's most likely to be using technology versus who isn't. And with AI, it tends to show up more with those earlier in their careers, not necessarily, but more likely. And the differences in how attorneys approach AI, again, are less about age and more about where an attorney is in their professional development and responsibility arc, coupled with what they're used to in terms of how they learn, how they work, also their openness to change. Career stages have a lot to do with someone's ability to use discernment in legal matters, their exposure to risks within their practice, also their confidence in their judgment, and how close they are to the consequences if something goes wrong. So generally, and this is not going to be the case with everyone, but generally attorneys earlier in their careers often encounter AI as a way to boost productivity. Their typical approach would be to use it for research or to summarize material, and they would treat it as a starting point we hope, a starting point with drafting documents. And it makes sense at this stage because they're still learning, and using these tools might already be a normal part of how they work and prepare assignments in general. And they're still developing professional judgment. So they might assume that anything they do that needs correction will just get corrected as it heads up the chain of review. So some of the risks that, may include over-reliance on AI or even incomplete verification of outputs before, putting it into their work. Attorneys more transitioning or in the middle of their careers, they're often at a point where they might be supervising others, they have their own work streams, and their judgment carries more consequences. So if they're using AI for work, they might be more selective and cautious about using it, and maybe just use it for things like internal research, idea generation, or maybe to assist with drafting. They've likely had enough experience to see how even simple errors can cause huge problems. So they may be more hesitant to use it for anything that is client-facing or even something that you would use in court. As for more senior attorneys, partners, general counsels, practice leaders, their experience with AI would more likely involve understanding the legal landscape and being able to advise on the risks and the strategies involved more so than actually using the tools themselves. Not saying that they wouldn't use AI for certain things, but their focus may be more on the long-term consequences because they hold most accountability if something goes wrong. So their instinct would more be to ask, what does this expose us to rather than, what does this enable? And because AI tools for workflows are relatively new, they've already built their careers without it. So they've had enough experience and ease of using discretion and managing their work without the need for it. So to now learn it and incorporate it into their tried and true style of work and success might seem more time consuming and inefficient, especially when it comes to, now I have to verify outputs and stuff like that. So they may have concerns also about AI undermining professional craft. So these generation gaps can be problematic when people aren't aware of their default style and they just assume everyone else sees efficiency, risk, and responsibility the same way they do. So it's important for leadership to consider career stage differences, so you have clarity and shared expectations on what's permitted. Ideally, you would define which AI is acceptable by, task and risk level, specify which tools have been approved for use within a company or a firm. You want to give proper training for those tools, and then you always want to reinforce that human judgment and verification is always required. You also want to set expectations around how responsibility evolves as attorneys advance in their careers and what that means for AI use. And for different companies and firms, the approach is going to be different, but for the most part, different career stages experience AI differently because the work is different, the risk is different, and the accountability is different. So you want to govern accordingly and in a way that matches how people actually think, decide, and work, especially across different stages of legal responsibility. So miscommunication. So I want to discuss one of the ways miscommunication can play out. This happened with a SaaS company. Now, this is a company, they already have longstanding clients in various industries, and they were now embedding an AI feature into just a few of their product offerings, which gave the option to toggle on or toggle off of this AI feature. So it's not that it was required or it wasn't a default when using the platform, but just the introduction of this feature set off flags and a line of questioning with numerous clients, asking about how else AI would potentially be used as part of the platform. And then came a bunch of requests for amendments with AI terms that they didn't anticipate having to negotiate on just yet. What was unique here is that many of the questions and concerns that they got were similar to ones that, they would have with their own vendors when, they're on the client side. So with the experience of being both a provider and a customer, they did have some guidelines on how to approach AI with their own vendors and licensors. But when it came to their customers, the legal team wasn't fully aligned on how to answer some of their questions. One consideration was, what are the statements that we can make now that would bring assurance to our clients about the safety of our AI, but at the same time won't restrict us and become untrue in the event that, our products and our services expand and are updated with more AI features, even a year from now as we continue to, keep up with all these new tech developments. Also, with parts of our programs that our clients use, we're bound to contractual obligations with our licensors and vendors for things like hosting or analytics and other tools. So those vendors, they might already be using AI or they might start to use it at some point. And at that time, there will be flow down terms that will come into play. And there may be changes around data use and confidentiality with, downstream compliance. So how do we resolve that with our clients? In this particular matter, the head of legal for one of the regions had the mindset of, yes, we know our clients have concerns, but they will understand that AI is now going to be a part of everything. So for now, let's just assure them that they can toggle off of the feature if there are any concerns. And here are some talk tracks that we can use if you do get questions. Now, this approach definitely had more of a future-oriented mindset. They were focused on the inevitability of AI and its momentum in all business functions, basically saying, this is happening. Let's not over-explain it so we don't have to go into a rabbit hole of concerns that our clients have. But the core disconnect here was that clients weren't asking whether AI exists. Most of their questions were based on how the risk can shift. So here, the legal team was put in a position to answer questions that they sometimes couldn't anticipate. And this turned into inconsistent messaging where they had to respond in real time, which might sometimes have come across as maybe dismissive or incomplete answers when, client questions started to escalate. Clients notice and sense uncertainty, and when they do, it affects their trust. So in this particular case, that mindset led to team members being underprepared for negotiation friction, and it pushed the legal team into reactive positions. So this is an example where when you're making decisions for a whole team, you really want to understand where your blind spots are. This individual really embraces change and the innovation and the ease of AI tools and the time it saves. So, but it overshadowed the consideration that, many others, especially business, have valid concerns about risk. So it would have definitely been helpful to understand ahead of time how this person's own line of thinking left gaps that had a trickle-down effect to legal and then also to the sales teams who were at the front line of this change. So you want to remember that, your excitement about AI and the usefulness that you find in it because of how it helps you might not be the same for someone else who is concerned about the risks or who perhaps doesn't find it to be as useful because maybe their style of work is different and it doesn't serve the same purposes for them. Or you'll also want to remember that your hesitation towards its AI or your hesitation towards or the concerns that you have about risk shouldn't undermine its usefulness for others where, the risk is generally low. So I hope these examples gave a sense of just a few ways leadership styles can affect AI considerations and matters. And there are many other ways, of course, but the bottom line is that this technology calls for a lot more thought, and it requires more than a governance blueprint and the technical knowledge. your strategy needs to resonate across teams, and self-awareness is important because your way of being impacts how teams not only use AI within the company, but also how they represent and communicate its use outside the company or firm. So I will turn it back over to Avi to guide us through some relevant case law and model rules that everyone should keep in mind, especially when using AI.
So moving forward, if we go back to our DISC profiles and our Myers-Briggs, we can make a generalization about leadership and attorneys as far as certain personalities tend to do better in those fields. Obviously, there are always exceptions. But if you think about yourself and your own profile, either DISC or Myers-Briggs or both, the overlap, if you lean more dominant, you want to remember the conscientiousness and the cautiousness aspect. Going straight forward without taking the time to double check the work can definitely cause problems, especially when we're using generative AI as attorneys and filings before the court. And a big reason why, if you lean more dominant, that you want to remember the cautiousness and the conscientiousness is because, at least for right now, generative AI still has a lot of steadiness in its outputs. Right now, generative AI is very kind of a people pleaser. And we'll see that as we get into some of these cases. It's not necessarily always giving you the right answer. It's giving you the answer sometimes that you want to hear or that it thinks that you're looking for. So this right here is kind of starting us off, and this is from the Second Circuit, which covers New York, among other jurisdictions. And kind of the big takeaway that you want to think about as you're leaving a CLE is that a licensed attorney must ensure their submissions to the court are accurate. And that's going to cover all of the rules, the 3 sample cases, and just kind of how you should be approaching generative AI if you're using it in your legal work. So here's a nice disclaimer. The fact that this presentation is neither meant to form or establish an attorney-client relationship or constitute legal advice. The onus of a reasonable attorney handling an AI-related matter is to conduct their own due diligence. Generative AI, artificial intelligence, agentic AI, they're all rapidly evolving technologies. And so you definitely want to consult your relevant local, state, federal, and possibly international laws before using or relying on any of its outputs. So we're going to start off with this first case, which is really just kind of fundamental to kind of the legal landscape in using generative AI right now. And that is Mana v. Avianca. So this is a 2023 case from the Southern District of New York. And you have an attorney who's not admitted to the federal court who's using ChatGPT with a statute of limitations issue. As a result of being unadmitted, they connect with an attorney who's admitted in the federal court, who ultimately ends up filing some documents with the court that were generated by the unadmitted attorney. The unadmitted attorney uses ChatGPT, and at the time could not fathom that ChatGPT would return false cases. And after some back and forth from opposing counsel, plaintiff's counsel, and the court, they determined that the cases used were hallucinated cases that invoked the name of real judges sitting at various courts across the country, but attributing to them false statements like inaccuracies. And as a brief aside, the unadmitted attorney, plaintiff's counsel, did ask ChatGPT if the cases were real, and ChatGPT confirmed that the cases are real. So Mana v. Avianca is a really crucial case that is cited in the other 2 cases that we're going to approach. And it really kind of made the public at large that aware of the fact that people are using generative AI. Whether you are aware of it or not, your employees are probably using generative AI either at home or at work. And if you're an attorney, people are using generative AI um, sometimes for legal research. And another key point in Mata v. Avianca is that the Rule 11 sanctions not only applied to the unadmitted attorney, they also applied to the admitted attorney and to the unadmitted attorney's firm. So all three were held responsible under Rule 11, Federal Rules of Civil Procedure Rule 11, and they had to pay a $5,000 fine, jointly and severally liable, as a penalty for filing these false cases in the court. And both attorneys also had to write letters to each of those judges that were wrongfully invoked. So it should have been a cautionary tale. In this case, took place in 2023, but we have two other cases that we're going to go to right now that show that Mata v. Avianca is not really the end of this. This is still ongoing. Attorneys are still using generative AI in their work and unfortunately still filing documents with the court that are not necessarily vetted or accurate. So that takes us to Park v. Kim, which is a 2024 case. And it was appealed by Park after her case was dismissed from the Eastern District of New York for using a reply brief that had non-existent cases. After some back and forth with the court, plaintiff's counsel did admit that they used generative AI in becoming responsive. Excuse me. And the court, Second Circuit, ultimately decided that the attorney's actions in this case fell below the basic obligations of counsel. So not only was the plaintiff's case dismissed, but the attorney also faced a referral to the court's grievance panel and had to provide a copy of the decision to the client, showing that their failings and shortcomings were the reason for the case dismissal. And so the holding we get from Park is that an attorney has a duty to ensure that all submissions to the court are accurate and that a reasonable inquiry is conducted to confirm the existence and validity of all legal authorities cited, regardless of the tools used to generate them. So the court in Park said there's nothing inherently wrong with using generative AI. But in the same way that you would double check the work of a junior attorney or a paralegal, that is also something that you must do as an attorney appearing before the court if you are using generative AI or other technologies. And just a little bit more on Park. Park does cite Mata a few times, and they mention the fact that the citation, specifically the citation she uses in the brief to a non-existent case, suggests conduct falling below the basic obligations of counsel, which was really the reason why they pushed for the referral to the grievance panel. As an attorney, as a member of the bar, you do have certain duties and obligations. But as we'll see in this next case, the court can still hold you accountable for improper filings and not using proper case law, even if you're not an attorney. So in Mata, we had an unadmitted attorney and an admitted attorney. Both of those two were held responsible, and the law firm. And then in Park, we have plaintiff's counsel, who is an admitted attorney, who is also being held responsible. So in this next case, from 2025, which is Hanson Jr., we have a pro se litigant who is also being held responsible. So in Hanson Jr., we have a person who initially filed in state court, and the case was removed by the defendant. So Nest Home takes it to federal court. And once it's removed to federal court, the plaintiff, who is a pro se litigant, not an attorney, is responding to the defendant's motions and documents to the court using what is later determined to be a generative AI model. There's a lengthy practice going back and forth between the two parties. And at some point, the defense attorneys reach out to the court and the defense attorneys determine that a number of the cases used in the filings contain hallucinated cases. So the court then responds to ask the plaintiff to show cause, meaning to provide additional information about where did you find these cases, what are the holdings of each of these cases, how did you find them, etc. And the plaintiff ultimately discloses that they used a generative AI model and that they were unaware that generative AI could return responses that weren't factual. So there's a lengthy delve into Mata v. Avianca and some other case law. And the court ultimately decides that considering the length of time wasted on the case, the diversion of resources to vet the case, that Rule 11 sanctions were appropriate under the civil procedure rules. So this is a pro se litigant, and that was a very weighted factor in determining whether the Hansen should be fined money or if it should be some other form of sanctions. And because of the fact that Hansen was a pro se litigant, the court ultimately decided to impose non-monetary sanctions. But the court also removed all of the cases that were hallucinated from the pleading. So going back to the initial complaint, all the way through the responses, all of that stuff had to be redone. The court also required a detailed certification of authorities moving forward. So that means, just like in math, the pro se litigant had to show their work for each and every legal authority moving forward. And the court also warned Mr. Hansen that should this continue, the case would be dismissed. So Hansen Jr., which is a 2025 case from October of last year, really shows that, at least on the federal level, our courts are starting to see generative AI more frequently on their dockets. And out of concern of judicial resources going to be diverted, judges being wrongfully invoked, and kind of the time that's taking place between attorneys who are balancing other cases and litigants either self-represented or represented by counsel, that is wasting a lot of time and resources in determining whether these cases that are being presented are even factual. So the takeaway from the three cases is if you're filing something in court, whether you're an attorney or a non-attorney, you have to make sure that it's truthful and accurate. And these are kind of going back to, law school. You have your ABA model rules. These are still the gold standard. And you also have the rules of civil procedure. So competent representation. The reason why people are hiring attorneys is because they expect a certain quality of knowledge, skill, and thoroughness and preparation. That goes back to the attorney in Park. The Second Circuit was very concerned with the fact that counsel didn't use Westlaw or Lexis or double check those cases that were returned by ChatGPT. And that was why that person was ultimately referred to the grievance counsel. And then if we think about 1.6, Rule 1.6, you want to be mindful if you're an attorney who's representing someone and you're using generative AI, not just because of the fact that it can give false outputs, but also because of the fact that there are data privacy concerns. If we think about the news or multiple emails where there was a data privacy link at this company, there was a data privacy link at that company, inputting a client's information into a generative AI model can violate 1.6, especially if the client's unaware of it. Right now, generative AI models are kind of acting as a black box. We put things in, but we don't really know what happens inside the model before we get the output. There's definitely a lot in the tech sphere about AI being a black box, which I would be happy to discuss post. But if you're an attorney, you want to be mindful about what information you're putting in the model. And that's whether you have a closed box system specific to your firm or you are a subscriber versus a public model. You really want to know the details of that privacy clause. And if you are using generative AI models in your legal work, you also want to make sure that your client is aware of it and has consented to their specific information being input in those models. And then getting back into the court itself. So Rule 3.3, candor to the court. An attorney or a person appearing shall not make a false statement of law or fail to correct. So in Mata v. Avianca, in Park v. Kim, and in Hansen Jr., all of those individuals had opportunities to correct their error before it got to the level it did. So in Mata v. Avianca, you had the unadmitted attorney being kind of that main push in using generative AI. The admitted attorney was not aware that the unadmitted attorney used generative AI, but neither party corrected that mistake. Defense counsel brought it to the attention of the court. The court then reached out to the attorneys, and rather than kind of owning up to it immediately, they kind of dallied and continued to drag it out. The same thing in Park v. Kim. So the attorney didn't double check the work of generative AI. Defense counsel brought it up like this is a hallucinated case. The court confirmed that it was a hallucinated case. And then you had a back and forth between the attorney and the court for an extended period of time before essentially owning up to the fact that they used generative AI and they couldn't find the cases themselves. So you definitely want to make sure that anything you're filing in court, you've double checked and that you know that it's good law. It's not a problem inherently to use generative AI, but using generative AI without double checking the outputs in the same way that you would a paralegal or a junior attorney definitely can cause issues not only for you, but also for your firm if you are working with a company. And then we want to think about representations to the court. So Federal Rule of Civil Procedure 11, you have a reasonable, or apologies, you have an objective obligation to conduct a reasonable inquiry to verify what you're filing is accurate. Otherwise, you can risk sanctions, and that's whether you're an attorney, admitted, unadmitted, or a layperson, a non-attorney who's appearing in court. And that is that.
Wonderful. Well, thank you both so much for sharing that presentation with us. We can go ahead and move on to some questions. I know we have a few more minutes until you reach our full 60. So if anyone in the audience has questions, please feel free to submit them. You can click into the Q&A button in the control panel at the bottom of your screen and then send them in there. And I will read those out to you both. All right, our first question is here. It is, how do you feel leadership personality styles influence whether Gen AI is adopted responsibly or recklessly within legal organizations? So how can personality impact AI usage?
Alicia, do you want to take it around?
I will briefly say it can go either way. It can go either way based on the individual and their type. So how do they, is it recklessly or responsibly? It can go either way, as you see with my examples. So that's why you want to be mindful. And as I said, make sure you know what your blind spots are. If you are managing a team, always consider the team as well. Know that your decisions impact your team and they're looking to you for, they're pretty much going based on your energy as well. So it's not an I thing. So again, just be mindful of your preferences and make sure you're representing the company or the firm in a way that aligns with the mission or the goal or the project. And make sure you know you're taking a balanced approach when it comes to AI.
So thank you, Alicia, for that insight. Our next question is, what risks arise when AI adoption decisions are made without leadership self-awareness or that ethical grounding? So both those personality elements, being aware of that, and then also what some of what you just touched on, Avi, the ethical pieces as well.
I can take this one. So, knowing yourself is really helpful just in general. Having self-awareness, how you naturally respond to certain things. And at least in the generative AI use I've seen, um, some people kind of rush into new technologies, whereas others are a little bit more cautious. And so I would say knowing either your DISC or your Myers-Briggs or both can help you understand why you're responding in the way that you are, especially when it comes to something new like generative AI, which is being used across the board, whether you're aware of it or not. And I would say that if you're in a leadership position, being mindful of your personality type versus that of an employee or someone who works with you or under you, that might also inform their way of approaching generative AI. So if you have someone who's either very for it or very against it, you want to think about who they are as a personality type and who you are. So I would say, generally speaking, the people I've encountered who are right now anti-generative AI are concerned from a risk perspective. They are concerned about how this is going to play out either legally, ethically, or just in general. They're concerned risk-wise. And then for the people who I see who are moving forward kind of expeditiously, they're looking at it from its an efficiency standpoint, more time to focus on other things, possibly for employment decisions, reducing the workforce and using generative AI as an augment. And circling back to the profiles, understanding who you are and who you're working with can inform why they're making those decisions. So it really kind of gets to the why behind the actions.
Awesome. Thank you, Avi. Our next question actually really nicely builds on that. So, you talked about how awareness of both self and maybe employees that you're overseeing and their personality types can help you understand how they might be dispositionally towards AI. But this person asks, how can you build on that as a manager, someone who is overseeing people, and utilize that information from DISC or Myers Briggs to how you'll approach AI governance or policies within your firm or organization?
I don't mind taking this one. So knowing yourself and knowing who you're working with is helpful in understanding how they might already be using generative AI and what guardrails need to be in place if there aren't already guardrails in place. So looking at it from an in-house counsel perspective and also from a risk perspective from government, you want to have guardrails because it prevents some of these cases like Mata v. Avianca, Park v. Kim, or even Hansen Jr. By establishing set protocols. So this way your staff knows what the expectations are. When people are using technologies or just in general, if you don't have a directive, people are going to default to their natural inclinations. By adding guardrails that have been established from a top-down level, you kind of set the expectation and the tone, regardless of profile. You're naturally going to have some people who are more cautious, and you're going to naturally have some people who are more energetic in their adoption. So by establishing set guidelines, it works for your specific firm or your specific company to make sure that the risk is within the level that you guys as leadership are comfortable with.
And I just want to add, I think it's now becoming more standard for companies to have AI use policies within the organization. So there already should be something in place that everybody can refer to. So, yeah.
Awesome. Thank you. And we have a question from Mai. They ask, can the bar rules violations, you mentioned several model rules, can violations of those lead to malpractice for unadmitted attorneys who are working, even if they aren't admitted? Would that still impact them, to your knowledge?
I would double check with your local jurisdiction. Going back to Mata v. Avianca, that was kind of a very big generative AI case. They have been used as a foundation for a lot of cases moving forward. the court gives a very lengthy piece by piece as far as the way they ruled. So as far as being unadmitted, I don't want to give a strict yes or no response, but it shows the current court climate shows that you can be held responsible even if you're not a licensed attorney. And we can kind of see that in Hansen Jr., where we have a pro se litigant who's being sanctioned for using fake cases. So the best practice across the board is to make sure that you're double checking the work, either in a reputable source that does legal research, or doing your own kind of due diligence at a local law library or something along those lines. You always want to fact check and double check the legal authorities that you're presenting before a court.
Awesome. Thank you, Avi. And then our next question is, how can leaders ensure that the AI assisted work that they create complies with Rule 3.3 and avoids those inadvertent misrepresentations in court?
So going back to Mata v. Avianca and Park v. Ken, those are both admitted attorneys. Well, one of the attorneys in Mata is unadmitted. But the same things that you would do before generative AI, you want to do that now. So I would say that generative AI models can give us a kind of a quicker response, but in the same way that you would double check your responses 10, 15 years ago, going to the law library, doing your own research, using a designated legal research tool like Lexis or Westlaw or Bloomberg, you want to continue to do that, even if you're using a generative AI model. The courts in both Mata v. Avianca and Park v. Kim stressed that it's not generative AI that's wrong. The attorney, as an attorney, has a responsibility to make sure that what they're saying to the court is truthful. And if the attorney finds out at some point that what they submitted to the court is not truthful or not fully elaborated on, that they're bringing that to the court, and it's not your opposing counsel or court clerk or the judge who is saying, hey, this is wrong. So you can use the model, but you have to double check the work always.
Thank you, Avi. And then our next question is, if I'm a more dominant person, so I think this person's using the DISC profile. If I'm a more dominant person, should I look for more conscientious people to hire? Is it important to balance your blind spots with other staff that you may have around you?
I wouldn't necessarily see you need to, I wouldn't say you need to balance your spots with other people. I think it's more of an internal and professional development exercise for yourself. If you know yourself to be a certain way, understand that in making your decisions or whatever, you tend to lean in favor of a certain profile. So be mindful. You don't necessarily have to hire the gap. Be mindful of the gap and try to account for it in your decision making.
I agree with Alicia. I would definitely say you don't have to make a hiring decision specifically based on personality type. I'm pretty sure you're not allowed to do that. But for me personally, I do find that having teams that complement each other is helpful, because you do fill the gaps and the blind spots, but also having self-awareness, which it seems that you do because you identified yourself as leaning more dominant type. Sometimes taking that pause, whether it's like 5 minutes, a short walk, to really kind of assess, have I looked at the different angles for this specific decision before I've decided to act? So sometimes the pause, regardless of your personality type, is helpful in kind of whether you execute or do something else before making a decision.
Wonderful. I think those are all the questions that we have time for today. So thank you both so much for your presentation and answering our audience questions. And thank you to all of our audience members who submitted questions. We always really appreciate your participation. All right. Well, we want to thank you all so much for joining us for another Justia webinar. Before you go, don't forget that Justia Connect Pro gives you access to that CLE credit opportunity for both live webinars like this one and unlimited on-demand webinars. listeners, helping you stay informed and meet your requirements. Pro members also enjoy an enhanced directory profile, the AI-powered Justia chat to capture more leads, and $200 off of select Justia marketing solutions. You can take advantage of these benefits and sign up today at pro.justia.com. Thank you all so much for joining and have a great rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.